A landmark ruling today by a D.C. federal judge marks unconstitutional a 20-year-old law requiring commercial filmmakers in national parks and on other federal lands to obtain a permit. I'm Jason Epperson, this is RV Miles, and here we talk about the latest in RV and camping news and often our national parks and public lands news. And today there's some really big news that affects national parks and other public lands, and especially affects vloggers and people like me who record videos for YouTube. We recently reported on popular bloggers and vloggers Kara and Nate, who released a YouTube video about their fine from the National Park Service for commercial filming on public lands without a permit. A law passed back in 2000 required the Secretaries of Agriculture and the Interior to require a permit and establish a reasonable fee for commercial filming activities or similar projects on federal lands. The law was an attempt to compensate the federal government for the costs involved in supervising film productions and to help protect our special places from activity that may cause harm. It's a noble cause, but the law was passed around the time that internet usage surpassed only about 50% of homes. It was 5 years before YouTube and 7 years before the iPhone. In the time since, the National Park Service and other federal agencies like the U.S. Forest Service have taken a hard line on the rule for anyone intending to make money, including news organizations and people that make pennies from YouTube revenue. Commercial filming has been declared by the National Park Service as recording of a visual image or sound recording by a person, business, or other entity for a market audience. But there's no real definition of what a market audience is. This includes recordings such as those used for documentaries, educational programs, television, feature film, advertisement, you name it. There's an exception for breaking news only, which some parks define as narrowly as anything that would cause a news program to break into regular programming. Not a lot of that happening in national parks. The national park permit process required an application fee that could range into hundreds and a shoot fee of at least $150 a day if you wanted to shoot for more than 4 hours, even if you're just taking a cell phone camera on a trail with you for a vlog. On Friday, U.S. District Judge Colleen Collar-Coatley took issue with that law, saying that the statute imposes a chilling effect on the expressive activities of a wide swath of national park visitors. Indie film director Gordon Price sued the government, challenging the constitutionality of the statute. In 2018, law enforcement rangers at Yorktown National Battlefield issued him a citation for filming without a permit for his feature Crawford Road. Price was filming by himself with a tripod and a camera. There have been very few challenges to this law, as often when a person who's been fined threatens legal action, the National Park Service backs down and rescinds the fine in order to avoid a negative ruling. In fact, in this case, the Department of Justice tried to argue that the court had no jurisdiction to hear the case since the fine had already been rescinded. But Price argued on his own behalf that he would like to film again at some point in the future and that a civil suit was the only way his case could be heard. The judge agreed, and she ruled in favor of Price, determining that the ban on filming in national parks was unreasonable in its scope, stating that a more specific law targeting film crews would have a better chance at being constitutional. Judge Collar-Coatley further issued a declaration that the National Park Service's requirements that those engaged in commercial filming must obtain permits and pay fees are unconstitutional under the First Amendment, and issued a permanent injunction against the practice. Since Price was only arguing about film production, the ruling does not apply to commercial still photographers, who are required to obtain a permit only if they're using more equipment than a camera and tripod or using models. I'd expect new rules about equipment use from the National Park Service and other federal land agencies in the near future in order to try and regain some control over film production that actually does disrupt conservation and public enjoyment of those spaces. But on a personal note, I think it's a win for freedom of speech. And I think it's important that people be allowed to whip out their cell phone cameras and their DSLRs when they're on public lands and take video no matter what the purpose is for. That's it for this video. I'd love to know your thoughts in the comments, and please check us out on the RV Miles podcast, available each and every week on any podcast app, full of all kinds of RV information. It's also available right here on YouTube.